Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. All right, so the fight between Gavin Newsom and Donald Trump continues. And it's in the court system now. And Gavin Newsom won a victory. Yesterday, a federal court ruled that Trump did not have sufficient grounds to federalize California's National Guard. But that victory was short-lived because as we slept last night, and I knew it was going to happen, the Ninth Circuit stopped the lower court, stopped that ruling, which basically means that Trump can continue federalizing California's National Guard. All right, so let's read a few things here. I simply love this stuff. Okay, it's the reason why I am a lawyer. All right, so let's look at some of this. The Ninth U.S. Circuit Court of Appeals on Thursday temporarily blocked a federal judge's order, underline the word temporarily, okay? Temporarily blocked a federal judge's order that directed President Donald Trump to return control of National Guard troops to California after he deployed them there following protests in Los Angeles over immigration raids. The court said it would hold a hearing on the matter on June 17th. That's this coming Tuesday. The following came only hours after a federal judge's order was to take effect at noon Friday. So once the lower judge issued his ruling, then the Trump administration immediately filed for a temporary restraining order. And what that basically means is they asked a higher court, the Ninth Circuit, which is known actually to be a very liberal circuit. So I was a little bit surprised that the Ninth Circuit went with the Trump administration. But nonetheless, they did. And so they issued a temporary restraining order, which means they said to the lower judge, I'm going to stop your ruling from taking effect for now, pending our hearing on June 17th. So we don't know how that hearing is going to go. All right, it's at that point that the appeals court, which will probably be, I presume, a 3-judge panel, not the full, what we call an en banc hearing. That would come later if someone requested it. But it will likely be a 3-judge panel who will hear the facts and the law and make a determination as to whether or not Trump, in fact, had the authority when he done so to take over California's National Guard. Okay? All right, so the article goes on to say, earlier Thursday, U.S. District Judge Charles Breyer, and by the way, this is former Supreme Court Justice Stephen Breyer's brother. Okay, so this is his brother. Earlier Thursday, U.S. District Judge Charles Breyer ruled the Guard deployment was illegal and both violated the 10th Amendment, which gives states considerable power. Okay, it's where we get the term states' rights. And it's amazing because typically it is the GOP that is arguing for states' rights. So usually MAGA, the GOP, would not be imposing on a particular state. And typically the state would not be, not a liberal state, let me be specific about that, not a liberal progressive state like California would not be making a states' rights argument. But these are strange times. But anyway, the deployment was illegal and both violated the 10th Amendment and exceeded Trump's statutory authority. The order applied only to the National Guard troops and not Marines who were also deployed to the LA protests. The judge said he would not rule on the Marines because they were not out on the streets yet. So he would have, but they were not literally, out doing anything on the streets of LA. So California Governor Gavin Newsom, who had asked the judge for an emergency stop to troops helping carry out immigration raids, had praised the earlier ruling. And here's what he said, quote, "Today was really about a test of democracy, and today we passed the test," close quote. Newsom said in a news conference before the appeals court decision, the deployment of the Guard was illegal and both violated the 10th Amendment and exceeded Trump's statutory authority. Now, I think both of these men, as I have alluded in a prior video, are doing a little political theater here, a little bit of hyperbole, right? It is because for Gavin to argue that this is a test of democracy, generally that would not be the case simply because a president federalized the National Guard. But we are talking about Trump. Okay, this is Trump. And we also got to point out that Gavin did not request that the president federalize California's National Guard. But my point is, it is not unusual for a president under certain circumstances to federalize National Guard. So that in and of itself is not a test of democracy. But again, we are talking about Trump. All right? We are talking about somebody who's attacking universities, law firms, et cetera, et cetera. Okay? So this goes on to say the White House had called Breyer's order unprecedented, also an attack on judges, the Trump administration, and said it puts our brave federal officials in danger. And I do want to underscore here that when I watched some of the protests, yeah, I did see people out throwing bricks and bottles and so on at federal law enforcement officials, ICE agents. Listen, that is illegal. That's not the kind of protests that people should be doing. The First Amendment gives us the right to peaceably protest, but it does not give us the right to break the law. And that is a violation of law to attack, to assault with bricks and bottles or with your hands or in any other way federal law enforcement agents. And I saw that with my own eyes. That is not the way to peacefully protest. All right. So, that's what the Trump administration said motivated them to bring in the National Guard and then, 700 Marines. Now, again, I've already said that we have seen this propensity of Trump to want to do this anyway. All right. And certainly, although people were throwing bottles and bricks and all that at those federal law enforcement agents, the LAPD or the California State Police certainly could have brought all that under control, definitely without Marines. I mean, the Marines are a lethal force, lethal. And the last thing they need to be doing is out there policing civilians like that. That's not what they're trained to do. Not at all. They're trained to fight foreigners and put them down. Okay? So the White House also said, and this again is why we have to take what Trump says and does in his administration different than we would regular presidents, because they go on to say, for example, quote, "The district court has no authority to usurp the president's authority as commander-in-chief," close quote. That is wrong. If the president makes the argument that judges cannot find his actions constitutional or unconstitutional, then we have a king. We have an autocrat. We have an authoritarian figure. We have a dictator. No, judges, federal judges, have the responsibility as Article 3 judges to determine whether or not the executive branch or the legislative branch has violated the Constitution or federal law. That is not ground that we can concede to the Trump administration and remain a democracy. We cannot do it. All right? In fact, let me go now back to that article, because the Trump administration goes on to say, quote, the president exercised his lawful authority to mobilize the National Guard to protect federal buildings and personnel in Gavin Newsom's lawless Los Angeles. The Trump administration will immediately appeal this abuse of power and looks forward to ultimate victory on the issue, close quote. Now, they're right that the president has the authority to mobilize the National Guard to protect federal buildings and personnel. There's no equivocation about that. The equivocation comes in when it is believed that he authorized or mobilized or federalized the National Guard in violation of federal law or the U.S. Constitution. And who is it that can review that decision? Federal courts. Okay, federal courts. That is their job. That's what their job is expressly. So that's why this case is so really important here. And that's, why Gavin said that this is a test of democracy. Okay, a little bit hyperbolic, typically. Generally it would not be hyperbolic. But in this case, dealing with this administration, as I said before, I can see that. All right, so let's look at what he says in his opinion. On June 6, 2025, the federal government initiated immigration raids across the city of Los Angeles. Protests swiftly followed, and some individuals involved in those protests were unruly and even violent. So we all acknowledge that. State, and it's not okay, as I said before, it is a felony. Okay, it's a felony offense. It is a felony offense, a federal felony offense that carries prison time and as much as about $500,000 in fines. So it is serious. State and local law enforcement responded. The following day, President Trump ordered that members of the California National Guard be federalized and thereupon assume control of those forces. At this early stage of the proceedings, the court must determine whether the president followed the congressionally mandated procedure for his actions. And in 3 words, he says he did not. His actions were illegal, both exceeding the scope of his statutory authority and violating the 10th Amendment to the United States Constitution. He must therefore return control of the California National Guard to the governor of the state of California forthwith. So that was a victory for Newsom. Now, I want to show you the part of this opinion where the judge addressed whether or not he had any authority under the Constitution to say whether or not Trump's decision to federalize the National Guard was or is permitted under our Constitution, under our laws. So he addressed that, and he addressed that early and first in his opinion. So here, I have it underlined. It's so very important. Defendants also challenge whether the court can properly evaluate whether these conditions were met, asserting that Section 12406 reserved this determination to the president's discretion alone. So he is challenging, the judge is going to review their challenge of his authority to say what the president did was or was not constitutional. Because remember, they called it the judge usurping the president's authority. Somehow it's in their minds that federal judges have no authority to determine if the executive branch is violating the Constitution. That is just simply not the law in the United States. And you learn this pretty early in law school. You learn it your first few days of constitutional law. All right, and for me, that was almost 25 years ago. Okay, let's look at this. This presents a preliminary question for the court to resolve before addressing the merits of Section 12406, Conditions for Federalizing the National Guard. And by the way, this is 10 U.S.C. Section 12406, Title 10. And that's where the authority lies for a president to federalize National Guard and other forces. So the judge deals with it straight up. All right? And here's what the judge says. It is emphatically the province and duty of the Judicial Department to say what the law is. Marbury v. Madison. It's an old case that established maybe 300 and something years ago that federal courts, Article 3 courts, have the authority, the sole authority of determining what the law is. So he just simply quoted that case. Thus, federal courts have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The Supreme Court has recognized only limited exceptions to this general rule, one of which is known as the political question doctrine. This doctrine recognizes that certain questions in their nature are political or which are, by the Constitution and law submitted to the executive, can never be made in this court. So basically, the political question doctrine just simply says that federal courts cannot weigh in on whether something is politically correct without there being some sort of case or controversy that is before them. Now, they make those political determinations all the time if a case or controversy is sitting before them. But if the Congress just wants to get an advisory opinion, say, from SCOTUS, from a federal judge, they typically cannot do that. There has to be a case or controversy before a federal judge has authority to say whether or not the executive or legislative branch or some other court has taken actions that are in violation of the Constitution or federal law. So the Trump administration is just wrong on that. And again, it's really, really, really simple, very, very simple legal precedent, long-standing legal precedent. Okay? And that's why Gavin Newsom was right to say this is a test of democracy, but only because of Trump's history of testing our democracy in other ways. Again, like attacking judges, attacking the media, attacking universities, attacking law firms, attacking the arts, and so on. All right? A higher court, the Ninth Circuit, stepped in and said, we need to look at this. All right? They said, we need to take a look at this, and that's because it is pretty typical for presidents to federalize the National Guard. So they jump right on this, and they want to make sure that the lower judge is right on this, or the Trump administration is right on this. So for now, Trump can continue to keep doing what he's doing with the California National Guard. And if he's able to win here, then this will probably be the way he does things across the country. So it is really important that the courts get this right. Because as Gavin said, this is a test of our democracy. But in this really short opinion order, actually, they said, okay, we need to take a look at this. And it just simply says, the court has received the government's emergency motion for stay-in pending appeal. The request for administrative stay is granted. Now, all that means is, let me explain that first sentence. The Trump administration filed an emergency motion for stay. Stay means stop. Stop the lower judge's ruling pending the appeal, because the Trump administration has or will appeal the lower judge's decision that what Trump did was unconstitutional. They are appealing that, or they will be appealing that shortly. And so they're asking the Ninth Circuit to stop the lower judge's ruling while the appeal is making its way through the court system. The appeal is going to be heard by the same court, the Ninth Circuit, okay? And from the Ninth Circuit, whoever wins or loses, whoever loses can ask the U.S. Supreme Court for a writ of certiorari. So that's where that is now. But they go on to say the request for an administrative stay is granted. The district court's June 12, 2025 temporary restraining order is temporarily stayed pending further order. The response to the emergency motion is due June 15, 2025 at 9 a.m. So they're saying that the state of California and Governor Newsom has to file their response to Trump's emergency motion by June 15th, 9 a.m. The optional reply in support of emergency motion is due June 16th. He's saying there that the Trump administration's reply to Gavin's response is due the next day on the 16th, okay, at 9 a.m. And then the panel, so like I said, it's a 3-judge panel, will hold a remote hearing by Zoom on June 17th, 2025 at 12 p.m. And then that court, the Ninth Circuit, will determine whether or not the lower court's order can stay in place, whether he will lift the stay, or whether Trump can continue federalizing the California National Guard. So we are all waiting now, with bated breath, on the Ninth Circuit's decision, maybe as soon as that Tuesday, if not certainly a couple of days or weeks afterward. Okay? So that's where this case is right now. I am Reverend and Civil Rights Attorney Augustus Corbett. Thank you for watching this video. It's really important what's going on in our nation right now. You need to stay up on things. And it's my responsibility, I believe, as an officer of the court, as a licensed attorney, as a civil rights attorney, as a criminal defense lawyer, as a citizen, as a father, as, having a family. My responsibility is to use what I have to keep you informed with the truth, and especially from the African American perspective. As always, stay woke.